HOA. My name is Steve Braten, and I'm the shareholder that oversees our association practice group here at Rosenbaum. Been practicing about 30 years now, and today we're going to be talking about elections for condos and HOAs, the various different processes and things you need to be aware of as we move into election season. So let's go ahead and get started. And with any luck, this will move. There we go. Okay. So just briefly, we'll just talk about how members can end up on the board of directors. If you happen to be a community that's still under developer control or recently turned over from developer control, then you know that the developer appoints the initial board of directors to operate the association. And then after turnover, the members select at least a majority of the members of the board of directors. And that is by election. And then if for whatever reason an elected director resigns, then the remaining directors will fill that vacancy on the board. And typically that'll be for the balance of the term of that seat on the board, unless your bylaws say the vacancy is filled until the next annual meeting. So the default is for the balance of the term unless your documents say something else, okay? And then once the once you appoint somebody to the board, bear in mind that that board member cannot be removed by the board that appointed that director. You'd have to have the membership recall that director. So when you are filling vacancies, you want to be cognizant of that fact, okay? Now, to be eligible to serve on a board of directors, you must be at least 18 years of age. And for homeowners association, you cannot be more than 90 days delinquent in the payment of any assessment or other monetary obligation. And for condominiums, you cannot be delinquent in any monetary obligation. And as of the last date that you would be eligible to serve on that board, or eligible to run as a candidate for the board, which is the date that your notice of intent to run is due under the Condominium Act, which is 40 days prior to the annual meeting. When you're calculating deadlines, and we'll get into this a little bit later in the Condominium Act, you're going backwards from the annual meeting date, not forward. So you can run into a calculation issue if you do it, if you calculate it the wrong way. If somebody's been convicted of a felony and their civil rights have not been restored for a minimum of 5 years, they are not eligible to run for the board of directors, whether you're a condo or HOA. When we're talking about civil rights, we're talking about the right to vote, the right to serve on a jury, and other civil rights, including, for example, the right to bear arms. The division has taken inconsistent positions with the issue of right to bear arms. I'm not going to get too much into that, but their last word was, so long as your other civil rights have been restored, your right to bear arms does not have to be restored, okay, to be eligible to run. If you've been charged with a felony theft or embezzlement involving association funds, you're not eligible while those charges are pending. We said that that's condo only, and that was just recently also added to the Chapter 720, the HOA statute, in this last legislative session, okay? And then co-owners may only serve on a board of directors if they own more than one unit or if there are not enough eligible candidates to fill the vacancies on the board at the time of the vacancy. So those are the only two exceptions to co-owners serving, okay? With regard to condominiums, I'm going to say maybe 5 years ago, the legislature added a term limit for unit owners serving on a condominium board, and that's 8 consecutive years. That issue was, I think, clarified in 2018 so that it was prospective, not retroactive. So you'd have to be serving 8 consecutive years from 2018 before this really becomes a problem for you. And even then, there's a provision that says you can still run, but you have to receive a certain amount of the votes of the unit owners to remain on the board. And I believe it's 2/3 of the owners participating in the election for you to continue to serve. or if there's not enough candidates to fill the vacancies on the board, you can still serve. Now, if the number of board members whose terms are expiring at the upcoming annual meeting equals or exceeds the number of candidates, the candidates become members of the board effective upon the adjournment of the annual meeting. It should say equal or is less than the number of seats on the board. So in other words, if I have a 5-member board and I have 5 candidates, I don't have a contested election. And if I have less than 5 candidates, I also don't have a contested election. It's only when we go over the number of seats that we actually have to hold an election. Okay. And again, this is for condominiums, but that also applies to HOAs. When we talk about what's the size of my board of directors, that's typically going to be fixed either in the bylaws or your articles of incorporation. Oftentimes what we see in the articles of incorporation is a range that your board can be anywhere from 3 to 5 or 3 to 7, sometimes as large as 9. And then the bylaws may give you some more detail on who decides what the size of the board is. Is it the board of directors that decides the number of seats? Is it the membership? Do the membership have to vote to reduce the size or expand the size of the board? Those things are going to typically be in your bylaws. Also, term of office, that's also covered either in the bylaws or the articles of incorporation. And the Condominium Act was recently amended to go from 1-year terms, and then they said 2-year terms were okay, and now it says if your bylaws permit, you can serve even longer terms. So, depending on the size of your board, if you're looking at considering staggered terms, if I have a 5-member board, it makes sense to have 2-year terms. Maybe if I have a 7 or 9-member board, it may make sense to have 3-year terms, and that way every year I am electing a certain number of seats at the annual meeting. But by having staggered terms, I ensure that there's people on the board that know what's going on. So, I refer to that as continuity of governance. And I think that's a very important thing. And if your association does not have staggered terms and you put up all the seats on your board for election every year, that's something you may want to consider changing. Okay.
Steve, we had a question about how you verify if someone has a felony for the eligibility.
Well, so I get that question. Are we supposed to run criminal background checks on candidates in order to determine whether they're eligible to run? Okay, the Condominium Act, the HOA Act, the rules promulgated by the Department of Business and Professional Regulation do not say that a candidate has to consent to undergo a background check before they're allowed on the ballot. So, if your association adopts rules to that effect, I haven't seen any decisions that have upheld that. Essentially, when you send out your notice of annual meeting, that disclaimer is going to be on there. And if a person submits their notice of intent, the understanding is they're doing so representing that they qualify for serving on the board. And if you were to later discover that that person, in fact, was not qualified to serve on the board because they were a convicted felon, then they would be deemed immediately removed from the board. And also any actions taken by the board while that person was on the board are not subject to being reversed, overturned, or challenged. So, each association handles that issue differently.
And if the civil rights have been restored, when does the 5 years start counting? 5 years since that person applied to be a board member, or 5 years from the date of the election?
Okay, so you calculate that 5-year eligibility requirement going backwards from the date that they can indicate that they're a candidate. So for a condominium, it's when the last day you can submit your notice of intent to run for the board, which would be 40 days prior to the annual meeting. And for an HOA, which we're going to talk about here in a minute, depending on the homeowners association election process, it could be the date of the annual meeting. If you have a right to nominate yourself at the meeting, then you would calculate that 5 years backward from the annual meeting date, and you're going back to the date that the civil rights were restored. So that's how you would do that calculation. Okay. Now, when we talk about election procedures, the Condominium Act has a very specific election process. We're going to talk here first about the election process for HOAs, and that election process is not governed to the same extent by Chapter 720, but rather defers more to the association's governing documents with certain qualifications. So every homeowners association election process can be a little bit different than the community next door, so to speak. So for us as lawyers, that makes that very challenging because no HOA necessarily looks the same. Whereas for condominiums, it's a very straightforward process. So, for HOA elections, your documents may permit owners to show up at your annual meeting with general proxies from other members in the community, meaning they've essentially delegated their vote to a proxy holder, and then that proxy holder can vote for candidates as they see fit, including themselves, for the board. Or it may be a limited proxy, and what that means is that the proxy holder is essentially showing up at the meeting on behalf of the member to count towards the quorum, as well as delivering their vote to the association. So the member signing the proxy is specifying who they want to vote for, and the proxy holder is simply making sure that vote gets counted. So it's a very different thing. Limited powers for the proxy holder with a limited proxy. General proxy, the proxy holder can vote however they choose. Okay. And then there's the scenario where if the documents of the association permit, you can vote by secret absentee ballot. Now that starts to look a lot more like a condominium association election, which we'll talk about in a bit here. And then there's this scenario where I just had a meeting last night where the documents say you have to vote in person by ballot. You can't mail it in. You can't vote by proxy. You have to show up at the meeting if you wish to vote for candidates for the board. If you don't show up at the meeting, you can't vote, and your neighbor can't vote for you either. Okay. Now, depending on the community documents, if there's no advanced nomination process, then the candidate can nominate himself or herself at the annual meeting. If the documents provide for an advanced nomination process, then I'm getting somebody requesting to record the meeting.
That's fine.
Okay. If there's an advanced nomination process in the documents, then you may or may not be able to, you may be able to dispense with nominations from the floor of the meeting. It all depends on how the election process is set forth in the governing document. So that's something you're going to need to consult with counsel to figure out, how do we handle and whether or not we need to take nominations from the floor. In order to conduct an election for an HOA, you have to have a quorum. The statute says 30%, no matter what your documents say, meaning if there's a higher threshold, 30% is what's necessary for a quorum. So if I have 100 members, I need 30 members to attend either in person or by proxy to establish the quorum. For condos, it's only 20% by statute. Only 20% of the owners have to participate in the election to have a valid election. So as you can see, there's a different bar there. And as we talked about briefly before, an election is not required unless I have more candidates than there are vacancies on the board up for election. Now, if the governing documents permit secret ballot voting, including absentee voting, then there's a process that you have to follow. And this also presupposes we have an advanced nomination process, in which case we're going to send out a notice with a ballot of all the candidates that timely submitted their intent to run for the board. And you're going to have two envelopes, a secret ballot envelope and then a larger outer envelope where the member is able to write their name, their property address in the community, and then sign that outer envelope so that come the election, we're able to validate the eligible voting members in the association. before we open those envelopes and take out the secret ballot envelopes. Because once we open up those outer envelopes, we haven't conducted the validation process first. We have a election that's essentially subject to legal challenge. Okay. If the eligibility of the member to vote is confirmed and no other ballot has been submitted for that lot, meaning we don't have two votes for the same parcel, then we're able to open those outer envelopes, take out the secret ballot envelopes, and start counting ballots. Once we get into the ballot counting and we're looking at the ballots, there may be grounds to disqualify the ballot because the person voted for more candidates than they should have. So if we had 3 seats up and the person voted for 4 candidates, we have to disqualify that ballot. If we can't figure out who the person voted for because they crossed it out too many times, we may have to disqualify that ballot. So, there's different grounds for disqualifying ballots once we actually get into that process. Okay. Do we have any questions about HOAs? Okay. So now we're going to talk about the condominium election process. And as you're going to see here, it's very specific. Okay. We have a first notice that has to go out at least 60 days prior to the annual meeting. That notice is going to state date, time, and place of the meeting. It's going to provide the deadline to submit the notice of intent to run, which is 40 days prior to the election. It's also going to possibly include the notice of intent to run form. It should also perhaps include the written acknowledgement of receipt form that the association is going to use to acknowledge to the candidate, we got your notice of intent timely. And it's going to set forth those deadlines. And it's also going to state the eligibility requirements we talked about. Okay. Now, 35 days prior to the election, the candidate has the right to submit a candidate information sheet. One side of an 8.5 by 11 piece of paper. Now, 2 sides, 1 side. There's no requirement for the association to validate the information contained in that information sheet. And that information sheet can say whatever it wants. It may actually talk about the candidate's qualifications. It may talk about completely other things that may not be very flattering to the existing members of the board. Whatever it says, that candidate information sheet has to go out with the second notice of annual meeting, which we'll talk about in a minute. If the timely submitted candidate information sheets don't go out with the second notice, we have what you called a flawed second notice, and we have to send it. We have to correct it and resend it, and that could, depending on the mailer, push back your annual meeting date. And there's specific rules on that in the administrative code.
We just have a question. Are these all mirrored over for co-ops?
Yes. So for co-ops, you have the very same process.
That and say condo
Yeah.
co-op.
It's the same process for co-ops as it is for condos. So thank you for that question. A candidate can endorse another candidate, but the association may not endorse any candidates running for the board. So what does that mean? So I have current members of the board rerunning for election. They're considered a candidate. What we don't want is a letter going out on association letterhead endorsing a candidate or a slate of candidates. That's not permissible. Okay. And the statute does provide that the association cannot be held liable for any information contained in the candidate information sheets. Okay. We talked about the eligibility and the size of the board. Now, a couple of things to be careful of here. In condo co-op land, it's very risky to think you're not going to have enough members participate in an election process to where the board is going to roll over. That scenario is typically more likely in the HOA context, depending on the size of the community and participation rate, because you need that 30% threshold in HOA land, whereas in condo co-op land, we only need 20%. So if nobody puts in their notice of intent to run, that could be a problem. But I strongly recommend that if you're looking to run for the board, put your notice of intent in timely. Okay. The other thing for condos and co-ops, the default size of the board is under the statute is 5 members, unless the documents provide for a smaller size, which is 3. And you always want to have an odd number of board members so that we never run into a scenario where a motion can't pass because of gridlock 2-2 or whatever the case may be. So you always need to maintain an odd number, and if somebody resigns, you want to fill that seat as quickly as possible. Okay. Now, talking about the second notice for condo and co-op elections, that has to go out no less than 14 days prior to the annual meeting. It can go out as early as 34 days, because remember, we had that 35-day cutoff for the candidate information sheet. So as soon as I get those, if I can get out my second notice the next day, that's perfectly fine. And we have to include in that second notice package, reiterating date, time, and place of the meeting. The second notice is going to include the agenda for the meeting. It's going to have the ballot with the list of eligible candidates in alphabetical order by surname, and we're going to include the outer and inner envelopes to return. Also, there should be a proxy in there because we need that proxy to establish a quorum for the annual meeting. If we have other business we're attempting to conduct, and you may even want to include a third envelope to send back that proxy as a proxy envelope and label it as such, okay? You may have an amendment that you're voting on at the annual meeting, and so we need that quorum for the vote, even though we don't need the quorum for the election, okay?
Couple of quick questions.
Yep.
Can the first notice of the election meeting be sent via email?
So sending out notices by electronic mail can only go to those owners who have consented to receive notice in writing by electronic mail. So if you've got consents from owners, you can send those. You can send that notice out electronically. And as we're going to hear later in the presentation, if you're doing electronic voting and somebody has also consented to receive electronic notice, they're not going to need those return envelopes because they're going to be voting electronically, and you'd be able to send the second notice to them as well electronically. So that just all depends on whether you want to have your owners consent to e-notice. I will point out that once an owner consents to receive notice by electronic mail, their email address becomes an official record of the association, and any owner can request all email addresses for those people who've signed off on those forms. You also have to give the owner the right to revoke that consent, so you should have not only a consent form available, but a revocation form available if they ever choose to stop receiving notices electronically.
And hold on, stop
Sure.
there. So if people opt in for electronic voting, can they receive all of the information electronically?
So they have to opt in for both. If you opt into electronic voting only, then they're still got to receive your notice packages by mail. Okay, they may just want to vote electronically, but still receive everything hard copy in the mail. So it's going to depend upon how you set up your electronic voting resolution and forms that you have folks sign. You can give them the option to consent to e-voting and to consent to electronic voting. To electronic notice or just electronic voting. So it really depends on how you want to do it as a community. Okay.
Awesome. Is proof of notice affidavit required on both the first and second notices of the annual meeting?
Yes, they absolutely are. It can be done by one affidavit, but you need to confirm in an affidavit that the first notice was mailed and that the second notice was mailed and posted. So that second notice not only has to be mailed at least 14 days prior to, but it has to be posted conspicuously on property, whether you're a condo co-op. And also, I believe for an HOA, that second notice also needs to be posted.
And if you're a condo over 150 on the website as well.
That's right. Very good, Katie.
And then one other quick question before you keep moving forward.
Yep.
Condo ownership records conflict with public records. Which one do you?
Yeah, so you want to go by, so if the condominium's membership roster doesn't coincide with the property appraiser website, it depends. So if, for example, you have a new owner and the property appraiser reflects the new owner, then your membership roster is out of date. Okay, now you can have a scenario where somebody bought the property within 2 weeks of the election and the property appraiser's records do not reflect the new owner yet because they're behind. So if the new owner has a deed signed by the old owner and they present the deed at the meeting, then that's sufficient evidence that they're the current owner of the property and they're entitled to vote. So it can go either way. So, this is again why it's helpful to have, legal counsel at the annual meeting, just to address these types of issues as well as disqualification issues that can come up.
And I will just say to you, usually the clerk, I do those verifications because I'm an election monitor. So usually the clerk of courts is updated much faster than the property appraiser. So if you want to verify that, you can go to the clerk website and just double check it.
So meaning public records as opposed to the property appraiser website. The deed may be showing up in public record, but it hasn't transferred over to the property appraiser website because that's two different, governmental agencies, communicating with each other. So in terms of getting back to the election procedure for condo and co-ops, what we're looking at here on the screen is basically the same envelope process that we talked about earlier, where the HOA has absentee secret ballot voting, the inner outer envelope process. So I'm not going to explain that again. And let's see. So this is a nice list of grounds for disqualification. If the outer envelope is not signed by the owner of the unit, we're going to disqualify the ballot. If we have more than the proper number of candidates that have been voted for, again, when we get into the ballot itself, we're going to disqualify the ballot. If we can't figure out who they voted for, if there's more than one ballot contained in the same inner envelope, those are all grounds for disqualification. Now, one of the things that we run into with electronic voting is somebody votes by paper ballot and electronically. Okay, typically we count the electronic vote and disregard the paper vote if they've consented to e-voting. Okay.
So Steve, this is where we had a couple questions and I was waiting till this point. So we had some questions about the voting certificate.
Okay. Voting certificates are my favorite topic. Okay.
I know.
Eliminate them from your documents. That's my recommendation. They create.
Well, the first question is, are they required for trusts?
Okay. So when we start talking about voting certificates, it becomes a document-driven question, meaning every community's documents and every voting certificate provision is well, not every, but depending on what developer drafted what set of bylaws for you, or unless you've amended and restated your bylaws, that provision can read a number of different ways. It may refer to just corporations. It may refer to business entities. It may refer to corporation, business entities, and trusts. We take the position that if it refers to corporations, that covers all business entities, because a limited liability company is just a form of a corporation, essentially. With regard to trusts, if it doesn't expressly refer, the provision for voting certificates doesn't expressly cover trusts, then there's an argument to be made that the trust doesn't have to submit a voting certificate, and any one of the trustees on the identified on the deed would be eligible to vote for the unit. Now, I can't, if you've got more than one trustee and they can't agree on how to vote, then you've got a problem, and that vote is going to be disqualified. Okay, so my preference is eliminate voting certificates. They create more problems than they're worth, and the way you write the provision is simply to say, any record title owner of the property may vote, and you can't vote. There can't be more than one vote per unit or parcel, and that solves the problem. I mean, I have a lot of communities where it says if the property is owned by more than one person, you have to have a voting certificate. And when we tell a married couple they need a voting certificate, they get very pissed off. So it's just something we don't want to have to deal with.
And I will just say to you that if you're not planning on having your legal counsel at your meeting, and especially if you hire an election monitor or even for your manager, it's good to have a legal opinion on what your situation is on the voting certificates in advance of that meeting, so that there's no questions the night of. A written legal opinion, this is what you need or don't need, so that everybody's clear.
Yep. And also, if the division, if you have an election challenge because you've disqualified ballots, because there was not a voting certificate on file for that property, and a challenge is filed, you're going to need to produce to the division at least 2 years of election records showing that you have consistently required voting certificates over the last 2 election cycles and disqualified ballots based on voting certificates. And if you can't produce those records, you're going to lose the election challenge. And, so when we look at the statutes and the retention periods for election records, they don't go back 2 years. They say for a condo, it's 1 year, and they say for an HOA, I think it's 90 days. So again, coming full circle to what I said, voting certificates create more problems than they're worth. Okay. Let's see. If the election procedure is not followed, the election may be invalid, and the association may have to repeat the entire election process. And this is something you really want to avoid. If a mistake is made, let's deal with that mistake when it's first discovered. So, I've had a number of instances where there was an issue with the second notice, and it's better to just fix it now than fix it later. Okay. However, bear in mind that if an election challenge is going to be brought, it has to be commenced within 60 days after the election results are announced. And before you can file that petition with the division to challenge the election, you have to give the association notice that you intend to challenge the election process, what was defective about the process, and give the association a reasonable amount of time within the 60-day period to voluntarily cure the defects to avoid the cost of litigating the election. Okay. Now, unless otherwise stated in the documents, officers are elected by the directors. I've never seen a set of documents say otherwise. So after we have that annual meeting, we're going to have what's called an organizational meeting. Typically, that organizational meeting happens the same night or day of the annual meeting, an election, but it doesn't have to. If we've got a whole new board and we need to, have some, thought put into who's going to be president, secretary, treasurer, and vice president, we have to have that organizational meeting by law within 10 days of the election. So it doesn't have to happen same day, but then you're also in a bit of limbo, and that's not great either. So if you're able to do that organizational meeting on the same day as the election, that's preferred. And this is the only time that directors can vote by secret ballot, and that is for the election of officers. So we can do that. But when we say secret ballot, we don't mean go off into a room behind closed doors. We mean in front of the membership, but you can use a piece of paper or a ballot once you have a nomination for each officer position to vote. Okay, the members have a right to watch that process if they want to stick around after they hear the election results. Okay.
Can you repeat the requirement about the board president, for example, who may be running, not recommending a slate of candidates?
Oh, no. When we talk about endorsing candidates, I said that one candidate can endorse another candidate. So if you're on the board and you're rerunning and you want to endorse somebody, that's fine. You're doing that personally as a candidate. What we don't want to see is a letter coming from the association on association letterhead signed by, for example, somebody who's not running for the board, endorsing a candidate or a slate of candidates, because that's being done by the association, and the administrative rules expressly prohibit the association from endorsing a candidate or candidates. I guess they see that as an unfair advantage for those individuals. So that's a no-no, and that'll render the whole election process subject to challenge. So, with that, that brings us to the election voting piece of the presentation. So unless we have any other questions, I can turn this over to Bob and Lisa.
Let me just look here real quick. For Meet the Candidates Night. So is it okay and proper for a Meet the Candidates Night, even if there's nothing about it in the documents?
Yeah, so, a Meet the Candidates Night is at the discretion of the association. If the association wants to have one, they can. If you're going to have a Meet the Candidates Night, then the board should adopt a process at a duly noticed meeting as to how that is going to work. meaning how much time is each candidate going to get to present themselves and their background and qualifications, how much time they're going to get to answer questions, and or how much time people are going to get to speak to ask a question. And there just needs to be some organization behind that process so it doesn't turn into a free-for-all, and what was supposed to be a positive meeting turns into a negative. So I would just say that that's community specific, and if you're going to do it, let's lay out the ground rules so all the candidates understand what the ground rules are, just like when we watch debates on television and elections. No, they typically deviate from those rules, but and go over their time. But you do the best you can, and you try and set parameters. And then if it starts to go the wrong direction, you call the candidate night. You close it out. So, but yeah, I have a lot of communities that do that, and then I have a lot that don't.
Is it appropriate for candidates who are running, when there's a no solicitation clause, to create a website and blast everybody through Nextdoor?
Yeah. So that no solicitation is not the same thing as politicking for votes. So I'm not a huge fan of the Nextdoor website, but if somebody's out there trying to use social media to solicit votes from their fellow members, there's not a whole lot you can do about that. Now, if they're making statements that are defamatory about the outgoing board on Nextdoor, that is something I think you can put a stop to, or at least attempt to put a stop to. It's very hard to rein in people on social media, especially with Nextdoor, because Nextdoor takes a very hands-off approach to the things that get posted there, and they rely on whoever's administering that site to police the statements that are being made.
Can you just also confirm the quorum requirements for condo co-op and HOA, regardless of their docs?
Okay, so when we talk about an election, what's the participation rate I need to have a valid election? For condos and co-ops, it's 20% of the eligible voting members. So eligible voting members means people who have not been had their voting rights suspended, for example, because they're more than 90 days past due on their assessments, and the board voted to suspend their voting rights. And unless the board has, at a duly noticed meeting, followed the correct process to suspend voting rights, even if that person is delinquent, they have the right to vote. So be very careful there. So 20% of the eligible membership, that's all you need for a valid HOA or condo or co-op election. For HOAs, it's 30% of your membership. So if we're using 100 members as our benchmark, I need 30 to be present at the meeting at an HOA, in person or by proxy, before I can call the meeting to order and proceed to have an election. If I'm a condo or co-op, I need to receive in the mail 20 valid ballots, 20 valid outer envelopes that have been properly completed and signed, that are not disqualified to have a valid election. Okay, so hopefully that.
I actually encourage the managers to structure the condo and co-op election annual meeting agendas where the election is first. So you're just determined, because oftentimes, even if you do the separate envelopes and distribution properly, nobody follows directions.
Right.
Everybody puts the proxies in the one envelope, and you can't open those until the time of election.
Right.
So the proper way to really structure that agenda is to basically get your quorum for your election, do the election, and then determine a quorum for the remainder of the annual meeting.
100%. So hopefully that answers that question.
And that's it, other than I know we're going to skip electronic voting so that we can let Bob talk about that. But there was one quick question about that, which is more appropriate to Steve. And that is, does the board have to amend their documents to implement electronic voting?
Yeah, so the answer to that question is no. You don't need to amend your documents to permit electronic voting. All the respective statutes, condo, co-op, HOA, have a specific section that authorizes electronic voting, and there's a process that you have to go through in order to authorize electronic voting. Lisa, are you going to cover that? Because I don't need to get into that if you are.
Yeah, no, please go ahead, because
Okay.
we always recommend, check if you need to amend.
Sure.
We're not the legal counsel. So
Yeah, I mean, unless you have unless your documents specifically prohibit electronic voting, which I've rarely seen. Most of the old documents say you can vote by voting machine, right? The statute says that you have to give 14 days notice of a board meeting by mail, or if your owners have signed up for electronic mail electronically, as well as posted notice. So we need to do 14 days in mail and posted on property of the meeting at which the board is going to adopt a resolution authorizing electronic voting. And you have to have a written resolution implementing electronic voting. So if you're going to implement electronic voting, you're going to need your association counsel to prepare the appropriate paperwork to implement electronic voting, including the consent form that's required by the statute, including the revocation form that's required by the statute, and the affidavit of compliance. There has to be an affidavit signed by whoever did the mailing and posting that was done at least 14 days prior to that board meeting. So you want to make sure all the T's are crossed and all the I's are dotted, so that your election process isn't challenged because you wanted to do electronic voting, which definitely increases membership participation in the voting process. We've seen that quite a bit recently.
Okay. And I think, by the way, the quorum for the annual meeting is going to be determined in the documents, not the election, but the actual annual meeting.
Right. So it's very common where I see, for example, a condominium association, it says that a quorum for a meeting of the membership is a majority of the membership in person or less. It can be a third. It varies for condos and co-ops how much of a quorum you need to conduct other business at your annual meeting than electing a directors. Okay.
And is it appropriate for the board to give a recap to the members if they don't have a quorum, while the election is happening, or to discuss anything for the association?
Yeah, I mean, you can, look, practically speaking, people show up, they want to hear some things. You can give them some informal information, or you can do it at the organizational meeting immediately following the annual meeting and have the open forum at the organizational meeting of the board. That's in fact what my client did last night. We didn't have a quorum for the annual meeting. We went straight to the organizational meeting. There were people that took the trouble to show up at the meeting, and so of course questions were asked, and the board wants to hear what people have to say if they show up to a meeting. So you may not have the answers at that moment, but at least you give the people the opportunity to say what's on their mind.
Awesome. I think that's it for our piece. Thank you so much, Steve. Lisa, I'm going to go ahead and spotlight you, and you can get your screen shared and get started.